Good morning and welcome to the Morning Scoop for Friday, February 5th. This is your daily Buckeye Fix. I'm Tom Orr. The Minnesota game is in 209 days. The game against Michigan in 295 days. College football could be on the verge of one of the most seismic shifts the sport has seen in decades. At this point, it's a matter of when and not if college athletes get their name, image, and likeness rights. And that is something that's going to have an impact on everything from recruiting to media to, and yes, the EA Sports college football video game. My guest today is Dan Lust. He's an attorney and the co-host of the Conduct Detrimental Sports Law podcast. Dan, thanks for joining me.
Tom, a pleasure. I feel like we've been talking for a while online, so it's nice to put a name and a face to the handle and all that fun stuff.
Yeah, Dan was very active during the Big Ten's whole mess last summer and followed him then. He's been a great follow on Twitter. He's at Sports Law Lust if you're interested in following him there. And before we go too deep on the NIL stuff, I want to kind of set the stage with the last time the Supreme Court weighed in on one of the central pillars of the NCAA. That was the 1984 case, NCAA versus Board of Regents of the University of Oklahoma. There is a pretty decent argument to be made that a lot of what followed from conference realignment, exploding revenues, salaries, and everything else all stems pretty much directly from that decision. So can you share a little bit about that case and what was at stake there?
Sure. And we'll be transparent here. It's a case before I was born. Tom, a case before you were born as well, 1984. Guessing maybe close to it.
No, I was about 6, but I don't remember the time before college football was on TV everywhere and all the time. So but before I really
that's
remember.
That's what I was going to say.
Yeah.
So it's a case. It's not that old of a case, but as Tom had mentioned, the last time the Supreme Court took a case on college sports and the law of college sports, that was back in 1984. So it's not that normal to have basically 40 years go by and not touch an industry. So Tom and I will get into it over the course of our conversation, but the fact that they're taking a case is very important. So back in the 80s, there was again, people will view this as commonplace, but when I turn on the college football Saturdays, I can turn on any number of networks, be it ABC, NBC, CBS, Fox. There will be a game on somewhere. We'll say the landscape of college football television rights for a number of years, decades, was that there was one primetime game and there would be various regional games. And if the NCAA, the powers that be, they got to pick what those national games were. So schools and big schools at the time, defending national champions, Oklahoma, Georgia, some of the biggest schools in the nation basically created an entity, College Football Association, and they were basically going to say, hey, we want to create our own television rights. We don't want the NCAA be the ones that get to say we're on television once a week. That's not really fair to us. We think that there should be an open broadening of all college football rights across the country. So what the NCAA did back then, which doesn't, I'll say it and people can make their own conclusions. The NCAA in a not so subtle way basically said, if you guys are going to form your own entity specifically for television and negotiate your rights separately from us, the NCAA, we're not going to have you play in the NCAA. We're going to ban you. So that's what's called an antitrust law. And I'll give you some fun lessons that my antitrust law professor taught me back in the day. But that's what's called an illegal group boycott. Now, the NCAA can kind of do some of those things because there is no other show in town. Antitrust laws were created to basically allow competition between entities. So that's why you don't want for any particular purpose, right? There only be the one entity in a particular field. That's why we have Coke, we have Pepsi, we have Crunch bars, we have Hershey's bars. We have different brands that can compete against each other. There is no competing entity with the NCAA. It's the only thing that exists. So if you're just looking at it at a very high level, the NCAA appears to be operating as a monopolistic enterprise that has nothing really keeping it in check because they're not competing with anybody. So their action stemming from this television dispute spawned this lawsuit, the Board of Regents case, that made its way all the way up to the Supreme Court. Back then, 1984, the Supreme Court basically said the NCAA was wrong, that they were not allowed to basically, compress the television market only to the entities that they allowed. And this is what opened the door to, like you guys, like the Big Ten Network, any number of networks on the sun. Maybe we're oversaturated at this point, but this is a pure competitive market that allows colleges and conferences to do whatever they want with television rights. And that's the goal and the beauty of our country, that is pro-competition. We are not there, as you mentioned early on. It's a matter of when it happens. But we're not quite there as to pro-competition with athletes getting paid for their name, image, and likeness. That's really that next battle that seems to be on the horizon.
Yeah, so now, for the first time since that case in 1984, Supreme Court is now going to hear another case dealing directly with the NCAA. This is an appeal on the NCAA versus Alston case, and this has the possibility of being, potentially just as big a shift in college football as we saw in the years after 1984. So can you briefly explain what the Alston case is and why this is potentially going to be such a big deal?
Yeah, so this one is a little more minutiae. So what we have on trial, actually, there's probably one case we should talk about in the middle here because Tom, you and I were talking. We had a big announcement this week in the video game world. Am I right?
Yes, the O'Bannon case and the return of EA Sports college football. So yes, that's what triggered this whole discussion in the first place.
Yeah, so it's an important case, and probably chronologically, this is it's a 2009 2014 case. We should be they all kind of work together. The O'Bannon case did not go to the Supreme Court, but very important for a number of reasons. I'll touch it quick, and then we can see where it goes from there. But the Alston case is, in a sense, right. It's the case that's going up to the Supreme Court. It's a case that's touching on anti-competitive purposes. This is the Ed O'Bannon case alleged another anti-competitive, nature of NCAA. So what all these cases are in some sense is a challenge of the NCAA's ability to really walk free of antitrust violations. So back then in 1984, on this Board of Regents case, they said that the NCAA was violating antitrust law with decompressing the television market. The Ed O'Bannon case, it was alleged violation of the Sherman Antitrust Act because EA Sports and various, I think it's the college licensing company, were violating athletes' rights for creating a video game franchise that was based off of players' name, image, and likeness, and not giving them a piece of that cut. So coincidentally, that was also a case that was a California federal court case that went to, basically this name Judge Wilkin will come into play again with Judge Alston. But in that court, Ninth Circuit Court of Appeals confirmed it. Basically said that athletes needed to be paid for their name, image, and likeness if you were going to use it in the course of a video game. Athletes, and people will know this now, it was a big settlement, close to $100 million. It was paid out across a number of athletes. Athletes got anywhere between $5,000 and $10,000. Some got a little bit less, some got a little bit more. But they were paid because their name, image, and likeness was used to create this video game, EA Sports, that you, Tom, and I, I'm sure we loved and we played for years until it miraculously went off the shelves in 2014 as a result of this lawsuit. But yeah, that was again a violation of the athletes' rights, that they weren't being given. They were being restricted in terms of their wages because they were only allowed to get the value of their scholarship. They weren't being able to get paid for EA Sports. So this decision came down. And now at this point, maybe 9 years ago, 7, 8, 9 years ago, and essentially said that if the video game is going to happen and you're going to use players' images and likenesses, that you can. In a sense, you have to pay them, right? So, Tom, the reason, it's all relevant. I mean, and the reason I bring it up in this sense, it's a chipping away of the NCAA's power. They're basically saying, NCAA, you can't get this giant chunk of profit from the video games unless you're going to pay your athletes in some sense. So, instead of having a video game that we could have loved and enjoyed for the last, 2015, 2016, 2017, have Joe Burrow on the cover, maybe have Justin Fields on the cover, have any number of guys on the cover, we have no video game because the NCAA just said, well, we don't want our athletes to get paid anything. We're not going to deal with this problem. So, I guess chronologically now, this kind of brings us, Tom, to the Alston case. I'm happy to. I could talk for days, but I'm happy to answer a question. Otherwise, I could just keep going on and on.
Yeah, go ahead and lay out the Alston case, because this is a case the NCAA, correct me if I'm wrong, but I believe the NCAA has lost at the circuit level, and the NCAA is the one that's bringing this to the Supreme Court. Is that right?
Yes, and that's why I wanted to kind of give you that pattern. The O'Bannon case was decided by Judge Wilkin over in California, Ninth Circuit Court of Appeals. So when the Alston case went to that same judge in that same court, we kind of knew it was going to happen. So that wasn't really that unexpected that the NCAA was going to lose in this Alston case again. So the difference being in O'Bannon, that case was a case that the NCAA tried to get to the Supreme Court, and the Supreme Court said, no, we don't want to hear the appeal on O'Bannon. So in this Alston case, it's a case essentially for it's non-cash. It's, how do I phrase this? Basically internships and stuff that you could make as a student athlete that are above and beyond what you would get as a full athletic scholarship. So maybe reimbursements for your laptop. If you could do a post-grad externship, things that the NCAA views that if they're misappropriated and misused, it's a way to basically pay athletes under the table. God forbid you get an internship with a booster. I mean, like, that's such a terrible thing. But that's what they didn't want to allow. And that's what this Alston case is saying. And this is the case that was now done at the at the trial court level at federal court, and then again at the Ninth Circuit Court of Appeals, which is the intermediary level of federal court. The only court above circuit courts of federal appeals is the Supreme Court that answers to all the circuit courts around the country, go all the way to the Supreme Court. So the NCAA lost at that level. It's not the full it's not full name, image, and likeness that's on trial here. But there is the defense that the NCAA has offered and basically said, we'll see. Hopefully, people follow me. It's not so crazy, but in that 1984 Board of Regents case, the NCAA said we are an entity that should be given basically an antitrust privilege or an antitrust exemption because we do a lot of good for student bodies. We have a reason for doing what we do. It's to help student athletes, to help amateurs, if it's to protect our athletes. So even though the NCAA lost that decision in 1984, there's language in that decision from Justice Stevens, which some people view as maybe an antitrust exemption that was on the horizon if the certain case presented itself, that the court would actually side for the NCAA and give them an antitrust exemption. Not that it came up in the Board of Regents case, not that it came up in O'Bannon because it didn't get to the Supreme Court. The Supreme Court now in Alston, they've lost at the first level, and they're trying to get this up to the Supreme Court. They filed their briefs. This was on Monday of this past week. And we now know what they're trying to do at the Supreme Court level. They're trying to get this new Supreme Court with a weighted conservative bench to say, listen, the NCAA shouldn't have lost at the lower level. Why? Because we're going to give them a full-blown antitrust exemption. That's what they're trying to argue. They're trying to go for the jugular. They're trying to bring this all the way up to the Supreme Court. Listen, I'm one that's pro athletes' rights. I want athletes to get paid, whether they should get paid an unlimited amount of money, something else, but there's a happy medium that I think we're trending to. If you are one like me that is in support of athletes getting paid, it's a little concerning, and you should be a little concerned that this case, when the NCAA is making that argument for a full antitrust exemption, this is the case that they want to hear. For the first time in 40 years, they want to hear this case. So all the progress, and you and I, I'm sure we'll get into it, all the progress that we're making on the legislative level, at the state level, and the federal level, that could all be undone. Supreme Court comes in here like they did with baseball once upon a time and gives them an antitrust exemption, which would allow the NCAA full range to do anything and anything to really compress athletes' rights and athletes getting paid for their name, image, and likeness.
So, I mean, if that does not go through, if they don't get an antitrust exemption, the really interesting thing about NAL right now is there are a ton of different proposals going around along a bunch of different tracks. I mean, we just talked about the Supreme Court, but there are a number of states like Florida, California, which have already passed bills, had them signed into law about this. Florida is set to go into effect on July 1st of this year. California does not go into effect until 2023, although I think I read that they were trying to get that moved up. Ohio has not passed one yet, but it seems like it would be a disaster if there are totally different rules for, 50 different sets of rules for 50 different states. So, if the Supreme Court doesn't give them the antitrust exemption, what's going to happen with those? How do they get around having 50 different sets of rules for 50 different states?
It's going to be very difficult. And that's why people in the state of Florida are, we'll say, excited about this battle that's setting up. So I'll give people a brief timeline. And as always, Tom knows this, my DMs are always open. So if you have questions or you're curious how this could affect the Ohio State University, you're happy to reach out to me offline. But yeah, I think the timeline is very relevant. Back in pre-COVID, the end of 2019, California passed fair pay to play, which is I'm going to call it an entrepreneurship license. Schools aren't going to pay you, but if you can make money off of your name, image, and likeness, you can create a new additional revenue stream, and you can get paid for it. So pretty landmark, pretty groundbreaking. It's not going to go into effect 2023. Now, what that did is it set off a chain reaction across the country from states like Iowa, New York, really across the country, but Florida is the one that's most important. Their version of fair pay to play, it has its subtle differences, but it comes into effect in July of 2021, and it's only a couple months. So there is a world as of July 1st, 2021, where athletes in the state of Florida, so be it Miami, Florida State, Florida Gulf Coast, whatever sport you want to talk about, up and down the line, that Florida athletes can get paid. So if I am the LeBron James, right, of college basketball, right, and I want to pick my school, maybe, right, if I'm LeBron, and so I bring LeBron up for a reason. I think he said on record that he would have been an Ohio State athlete. Tom, am I correct?
Yes,
I think
you are correct. Yes.
Yeah.
Yep.
But if I'm that big of a deal and I'm LeBron, right? And once upon a time, LeBron went to Miami. He left the lovely state of Cleveland. He went to Miami. That's a world that could happen where all the top athletes and the top 5-star recruits They don't pick Ohio State. They don't pick LSU. They all go to Miami. They all go to Florida. They all go to Florida State if they can really make that much money. So that's the world that's setting up. So, I've been reading up on this, trying to figure out what's going to happen. There is a world where the NCAA and Power 5 conferences basically sue for an injunction over the state of Florida to not let them do this on July 1st. So we're setting up, right, the Alston case that you and I spent a lot of time talking about. Oral argument will be heard at the Supreme Court on March 31st. Okay, so that's one level of something that could save this world where everything's kind of all over the place. And then there's another level, right? If the NCAA allows this and it proceeds, there's a federal name, image, and likeness bill. So there's a lovely concept of law called federalism that states like Florida, like Iowa, like California can do whatever they want so long as the federal government has not stepped in. I was not, again, alive at this point in time, but there was a time in our country where the drinking age was different in each state. You could cross state lines and there was a drinking age. Now, then the federal government stepped in and set a drinking age across the country of 21. That's a world that we could have where the federal government steps in, creates a federal name, image, and likeness bill. That way, the state of Florida and Florida alone does not gain an advantage. So this July of 2021 is setting up for a lot of fireworks. The NCAA doesn't want that. Obviously, 49 other states don't want that, but Florida wants it. So setting up for a real issue that's going to probably have to go through the courts because, right, Big Ten countries not going to like if the SEC and ACC, whatever, different Florida schools are gaining that advantage. But that's what it's setting up to do right now because the NCAA has sat on its heels and has not come forward with their own name, image, and likeness bill.
Yeah, and they have been, as you said, lobbying various folks in the federal government to pass a bill that would handle this on a national level. None of those have gotten all that far. That doesn't seem like that's imminent that that's going to get solved. And if you go to the NCAA's website, of course, they're saying, no, it's fine. We have this all under control. We're working on our own plan, which, reminds me of the great Winston Churchill quote about America's. You can always count on Americans to do the right thing after they've tried everything else. That's the NCAA. Like, oh, no. Why are you doing laws? Like, no, we totally are going to do this. We just haven't done it for the last 40 years because reasons. What to you is the most likely outcome here? I mean, which of these things actually ends up being the pathway that decides this, and what does that potentially look like for players and schools?
So it's, you and I, Tom, were speaking before the camera got rolling, but this is such a great time to have this conversation because I've said it for, again, I'm someone that's pro athletes making money. I almost, in my world, I would have loved if the NCAA denied what's called certiorari, that the United States Supreme Court denied certiorari, and we just dealt with this through the legislator, because it looks like we're trending towards a world where athletes are going to get paid. It's just a matter of when. The issue, a little concerning to me, again, I brought it up, the Supreme Court is taking this case, and they have a right to impose in the way that the judges sometimes do, and that's why we have an executive branch, legislative branch, and judicial branch, to create an antitrust exemption out of thin air. So that will allow the NCAA to do a number of things, right? The NCAA has pushed back their name, image, and likeness bill or whatever. I don't even know if they're planning to do something at some point. I mean, they keep pushing it back, and right, it's been 40 years. What's another couple months of the NCAA? But yeah, I'm a little concerned that the NCAA is trying to just kick the can, and they're trying to wait for someone to bail them out, be it a federal bill, which I know they're spending a lot of money to try to lobby to get, or this new conservative bench at the Supreme Court level to create antitrust exemption. And if that happens, NCAA could do whatever it wants, right? If you don't want to be an NCAA member school, you can leave. And the NCAA has, in this context, threatened to kick the California schools out of the NCAA. I remember it because I know that's what I mentioned early on, a legal group boycott. But the NCAA has threatened to ban schools on any number of occasions over the years. So there's a world where the NCAA, right, might not exist as we know it, if they are trying to hold on to a level of control. And for example, the Florida schools want to leave, or fast forward, the California schools want to leave. The fabric of the NCAA is really being questioned. So even if an antitrust exemption does come down, and there's nothing holding the NCAA together, as we've seen during this COVID issue. And, obviously, Tom, you know my thoughts on the Big Ten situation. The fracturing of college football is very apparent. So I don't think that this gets better. Truthfully, with more tentacles from the legislative level, from the judicial level, I think the fabric of college football is changing. And if you're one that hates the NCAA, by all means, that's good. But we don't know what's on the other end of that curtain, which is fine. Sometimes change is good, but there are rapid changes really staring the NCAA in their face. So when you mentioned at the top, it's not a matter of if, it's a matter of when. And it's a matter of what this landscape looks like after the legislative and the judicial bodies, they all, we're picking we're like buzzards, right? The vultures picking at the corpse of the NCAA, what this thing really looks like.
And the reason we're talking about this now, we mentioned it earlier, the news earlier this week that the EA Sports College Football video game is coming back in a few years. And, they initially said, well, we're initially planning to do it with kind of generic players. Based on the timing, it sure seems like it's going to line up nicely for some kind of NIL deal to potentially be in place and be able to license players' names and images for the game. The tricky part there is the way they do it for Madden, for example, is they make a deal with the NFL Players Association. There is no College Football Players Association for EA to cut a group licensing deal with. So how would that work to actually get that done?
Rumor mill is it's not going to come into play this year. I don't think there's an official time on it, but why this is coming into play. I mean, I mentioned it earlier. The NCAA and EA Sports could have done this deal and have this generic game, whatever it exists. They could have had this done at any point really between 2015 and 2021. They didn't because they were, I guess it was a little murky legal situation. But I mean, by all means, that's what the court opinion said. They said if you're going to have a game like this NCAA football franchise and use name, image, and likeness and use players, right, like Eli Manning was number 10 and he played for Ole Miss and he looked a lot like Eli Manning, except his name was to be number 10. If you're going to be so blatant and obvious, you have to pay the athletes. That's the O'Bannon case. He looked a lot like Ed O'Bannon. He shot left-handed. He had Ed O'Bannon's number. He had the Ed O'Bannon UCLA jersey. All of his attributes are tight weight. If you're going to be that blatant, you have to pay athletes. So, with this world, it's, there's kind of a silver lining. It's a watered down world. You're going to have colleges, right? You're going to have Ohio State. You're not going to have Justin Fields. You're not going to have the same players, same attributes. But there's going to be just kind of generic, I guess, randomized players. Here's where I think, it's a shame, but this is where you can kind of get around. A shame for college athletes' rights, but maybe it's good for consumers. You have these generic rights, and just like you and I know, there's a number of mods you could download to basically get the full NCAA roster. That the good crazy people went to painstaking extents to edit all these different rosters and have these names. You could just download those offline, or you could be crazy like I've done in the past. I'll fully admit it, and gone through and edited all the names and made all the attributes myself. You could do that, right? You have edit player options, so you could make this world right and just not pay college athletes because you're saying, hey, I'm not profiting off their name, image, and likeness. I'm selling them a game that's customizable, which I'm allowed to do, and they're making the changes. So there's a world, right, where they don't have to pay college athletes. So it's a win for consumers, but it's not necessarily a win for student athletes. That's the part that I think maybe got lost in the shuffle of the game coming back. Denard Robinson was on the cover, right? That's the last NCAA that we're looking at. Maybe there's just generic player on the cover, right? This game is now called EA Sports College Football. It's not called NCAA football. So we'll see what comes of it, but it's not necessarily a win for student athletes, not yet at least.
There is potentially, though, a way for them to reach some kind of licensing agreement with players through IMG or one of those organizations, though, right? I mean, that's kind of another path, because my assumption is if they can do it with real players, I would assume they would want to, probably. But I mean, is there a path for them to do something like that?
There is a path, and this is the troubling part. It's a slippery slope. Do they have to do it? No, they do not. They by all intents, this generic watered down game without, right? If it's me, like, and I don't know if I'm in the majority minority of people that I like editing all the rosters. And I was telling somebody else, I play this game on my phone called Campus Dynasty. It's like a college basketball game. There's no Ohio State in the game. It's called then the Columbus Buckeyes. And I have to go, and it took me a very long time. I'm not going to tell you how long it took me, but to edit all of the teams and edit all the conferences and make it look accurate. And then, I'm in like 100 years in of dynasty mode, and none of the players are legitimate at that point. But that's the NCAA that I love, right? Everyone loves Madden because of the gameplay. The NCAA football video game gameplay is similar, but it's the customizable, the dynasty mode. And I don't know. I don't know if users are turned off that they can't play with Justin Fields with his attributes, right? Is it that big of a thing to just edit the team, right? And if you're 4 years into dynasty mode, all the players are going to be generic, randomized guys anyway. So is it that big of a deal? They're not required by any means to do that. But if they're going to outwardly, like they did with Ed O'Bannon, like they did with Eli Manning, and they did, with Jameis Winston of Florida State, like, any number of players down the line, using the attributes, using the height and weight, and profiting off of a use of a name, image, and likeness. But again, if you have the school's rights, which they're going to get from the collegiate licensing company, and the school's rights, school's uniforms, school's logos, school stadiums, maybe that's enough to draw in the consumer, and you don't have to pay ungodly amounts of money to student athletes. I'm not necessarily in support of that world. I'm just telling you, legally, they might not have an obligation to do that. And maybe economically, they wouldn't want to do that.
Well, I've asked you a bunch of very difficult questions without clear answers, and we're going to end with one that's maybe the most difficult with the haziest possible answers. I know you're a big Nebraska fan. With the Cornhuskers being the second most popular team in the Big Ten team in the state of Ohio right now, what is your feeling on the current state of the Huskers? What does success look like under Scott Frost? Like what is the ceiling for this program, and how do they get there?
Yeah, so Tom knows the backstory, but I seemingly became an honorary Cornhusker by defending basically the hatred around the country, which I didn't realize existed. I just thought it was unfair, and then I realized that nobody outside of basically the state of Ohio and maybe wherever I live, in parts unknown, but that support the Cornhuskers. So I support all things Cornhuskers. It seems like they don't have that much support, again, really outside the state of Nebraska and the state of Ohio. Yeah, I think there's a long road. I mean, they've had a number of transfers leaving in the transfer portal, which is a little alarming. But it's I don't know. I guess long term, right? Have the Cornhuskers experienced any level of success that they thought they were going to, and they left the Big 12 and they went to the Big 10? The answer is no. So the bar, and it's a good bar, the Big 10 competition has probably been a little bit more than they expected in terms of getting recruits, and that hasn't really happened. So it's alive and well. You're going to have to give it some time and give it some time in his recruiting. Yeah, I mean, I watched basically every minute of every Nebraska game this year. And again, I'm a newfound Nebraska fan, so by all means, I'm being very transparent with this. But they were in a lot of games they probably should have won. So I don't think the record is fully indicative of their team, but they lost a lot of games they shouldn't have lost. So we'll see. I think they're a lot closer than the record indicates. So I'm not ready to jump off the bandwagon yet. And as long as Cornhusker Nation keeps sending me and my lovely daughter free Nebraska stuff, I am going to stay on the bandwagon. I'm a gun for hire at this point.
Yeah, that was a tough end of the season. That Iowa game at the end, it was like, oh, they're going to do it. Oh, they didn't do it. That was. I'm sure a lot of Buckeye fans were kind of Cornhusker fans by association after all the offseason machinations, and that was a tough year to get on the Nebraska bandwagon. Will you please let people know where to find you on Twitter? I will recommend you as a Twitter follow. Let people know where to find you on Twitter, and also where to find your podcast, which features some of the best intro and outro music I have ever heard on any podcast ever.
Yes, well, I'm on Twitter and Instagram at Sports Law Lust. And as Tom knows, I speak at law schools and colleges around the country. I've spoken at almost every Big Ten school at this point. I'm speaking at Nebraska Law School in a couple weeks. Speaking at Iowa Law School next week. I've spoken at Michigan State, Rutgers. So if any law students at the Ohio State Law School want to hit me up, I'm happy to share my wealth of information. But yeah, I'm on Twitter, Instagram, Sports of Lust, and my podcast is called Conduct Detrimental, and we cover this intersection, a lovely intersection of sports and law. And as Tom kind of alluded to, we have our outro music as Brass Bonanza, which is a Hartford Whalers song. From I don't know. There's a longer backstory to it, but. Yeah, Lawyers, Guns, and Money is our intro music. That is a nod to a suggestion by Rob Dibble. I go on his ESPN show once in a while. He said that I am an idiot for not using it. So then I decided to use it and not be an idiot. Always good advice from Rob Dibble.
He throws pretty hard. You better listen to him. Dan, thank you for joining us this morning. Really appreciate it. And I'm sure we'll probably have you on at some point later on in this year as some of this stuff sort of shakes out and we get a little more direction on where this is all going. And thank you guys all for joining us. In addition to his great podcast, also make sure you check out all of the great Buckeye Scoop podcasts. They're on Apple Podcasts, Google Podcasts, SoundCloud, Spotify, Spreaker. Just search Buckeye Scoop to find all of those. You can subscribe right there. Also leave us a 5-star rating and review while you're there. Thank you guys all for joining us. Have a great day. Have a great weekend. And we will talk to you Monday.